Good evening and welcome on in for the part 2 edition of From Day 1. So let's grab the mailbag first. And today's ranking reward, 70 beautiful emeralds. Thank you very much. Alrighty, as we start grabbing the prizes, we'll start. First time ever we've had a nice, lovely lady as my partner in crime for the audio tonight. We're going to start with a judge who gets to handle a lady who, let's just call her what she is, an idiot, a super stupid sovereign citizen, whatever you wish to do. But along with me for the commentary, who do have a very good legal eagle attorney from the great East Coast, Natalie, the lawyer chick. So if everything's set, let's get to the court.
All right, good morning, Ms. Christensen. Can you hear me?
Yes, I can hear you.
All right, good morning. We are back on the record in the 53rd Circuit Court for the County of Presqu'île. Our next case on the docket is People of State.
Woman. Oh, let me see. You guys probably can't even see this. Okay. Woman, Angela Christensen.
You gotta love the
we already know that we're dealing with the sovereign.
You gotta love the.
And now a word from our sponsor at.
You gotta love. You gotta love the what they call what is it? Quantum grammar. You know, quantum grammar, aka the idiots. That's why you have that kind of name. They're basically using a sovereign citizen tactic of a lot of colons, dashes, periods, and everything else to punctuate what is correct for syntax.
Angela Marie Christensen, 21-93185H. We have Ms. Christensen attending by Zoom, representing herself. Washington attorney Mr. Radziban is here in the court.
I think it's kind of funny that it looks like she's home, appearing virtually, and for some reason is wearing a mask at home. And there could be reasons why you might need
and a hat.
Like maybe someone has been exposed or is positive, and you're trying to avoid contracting it. But then, like, she has it under her nose anyway, so it doesn't serve any purpose. And she's at home, so I just think that's kind of funny.
And the hat too.
Public access both in the courtroom and online. And Ms. Christensen, although you're appearing from your home, for convenience sake, it might not feel like a court hearing, but it is a court hearing, so I'm going to ask you to please remove your hat.
Thank you, Your Honor.
Oh, sorry.
No worries. Okay, thank you. All right, so as we begin the hearing, just like last time, I'm required each time to remind you that you do have the right to the assistance of a lawyer if you wish, and that includes the right to a lawyer at public expense if you were indigent, and that you've previously waived that right and wish to represent yourself. And so I guess I want to ask you again, do you reaffirm that you'd like to represent yourself in this matter, or would you like to have a lawyer?
No, I would like to self-govern, and I stand on my paperwork.
That does not answer that question.
Thank you for noticing, Natalie.
So think about it this way. Like, even if you believe that you are a member of your own government, you're the representative of your own government, you're separate and apart from the United States, even if a foreign government is sued, sometimes that happens, like they're sued or something like that, or they're brought before, or, you know, actors on the part of the government or brought before an international court or something like that. Even when that happens, they have counsel to represent them. There are lawyers for the United States. There are lawyers for the UK. There are lawyers that represent countries. So whether or not you're a sovereign of a particular country does not mean that you should not get a lawyer that can represent you. So maybe that's something judges could say. Like, even if you're sovereign and you stand on your own government, you can still have someone represent your government in court.
Okay. So what we have today, you did file 4 written notices that asked for some type of relief, and we had adjourned the hearing to today for any argument on that. So the prosecutor has had a chance to review them. So
Oh, that reminds me, Natalie, you're gonna love, love, love her notices. Let's just put them that way.
Ms. Christensen, you say that you stand by the paperwork, and that's fine. I do have the paperwork in front of me. Is there any argument that you want to make on your behalf right now to me in support of those claims, or do you wish to just rely on the written pleadings you filed?
It is my wish to stand on my paperwork.
Okay. Mr.
I would love to see that paperwork.
You don't worry, you get that opportunity.
Argument in opposition to those 4 notices?
Your Honor, I reviewed the paperwork, and I guess, while she may not recognize Your Honor state of the law, I don't believe there's any relief that's recognized under law that would allow you to dismiss this case based on what she's supposed to have made.
Okay. All right. Well, Ms. Christensen, now I'm going to make a ruling on the notices, which I'm construing as some motion or request for relief.
That's the judge being nice, because if she filed things captioning them as notices, probably notice of her sovereignty or whatever the case may be, those are not motions. You're not necessarily asking the court to do anything. The court only rules on motions. They need to have a motion with an order that they can rule on. And so there's really no reason that the judge even has to acknowledge improperly filed paperwork that doesn't conform with the rules, but he's choosing to do so here.
He wants to be nice.
And I've got a written order that I'll enter. Sure, I'll read it at this point. Defendant, who at this point in the case is representing herself, has filed 4 handwritten notices. These notices appear to seek relief in one form or another. As to the first notice, defendant asserts that she is a woman and not a defendant. The court finds that Angela Christensen is both a woman.
Hey, Natalie, you don't need to roll your eyes that bad. If you want to say something, actually say it. I'm sorry again. I get to see her. You guys are only getting the audio. But Natalie rolled her eyes when she heard that title. I told you get to. Yeah.
Woman and a defendant in this criminal action. To the extent the notice seeks relief, such relief is denied.
I mean, also true, right? Like, and it's of no moment. You know, you can be a man and a defendant, but you're the defendant here in this case. And yes, you also just happen to be a woman, which is far less important than you being the defendant. And the court will take judicial notice of the fact that she's a woman and a defendant and will not dismiss the case based on those reasons. Straw man arguments don't work here.
As to the second notice, defendant demands that any man or woman with a claim against her appear and present such claim in open court. To the extent that this notice seeks to invoke defendant's right to confront her accusers, this court will enforce that right. However, the right of confrontation does not require the complaining witnesses to appear at all pretrial hearings, but only the trial or any necessary evidentiary hearings.
Oh, that's a very good point. So sometimes people that are not sovereign citizens will have this question, and it's a really good question. So basically, it's before you get to the trial or the motions hearing, there's a lot of administrative hearings that can take place. And I don't mean they're judicial, they're in a judicial body, but I mean, like, think of like an administrative assistant, like just to take care of like the administrative parts of the case, like setting court dates, checking on discovery, making sure that there was a plea offer relayed, making sure the defendant understood it, making sure the defendant has a client, has an attorney. All of those are things that you can take care of in pre-trial, status conferences, arraignments, initial appearance, things of those nature. And the complaining witnesses, the witnesses for the prosecution, they do not need to appear at those hearings because it's not about whether or not the defendant is guilty or not guilty at those pre-trial hearings. It's about the administration of justice and making sure that you have your proper court dates that are scheduled within a timely fashion, in compliance with the Constitution, that you've been apprised of your right to an attorney, that you understand the process before you get to the point where you go to motions and or trial. So there's no need for a complaining witness to be there, and the courts, as in the appellate courts, have long understood that complaining witnesses are not necessary to be present in order for the court to follow through with that administrative function.
Thank you, Natalie.
So to the extent that this notice seeks to require the appearance of any complaining witnesses at all pretrial hearings, such relief is denied. As to the third notice, defendant asserts that this court lacks authority over her and that only her creator has that authority. Without gainsaying the authority of the creator, it can be...
Natalie, what did I tell you again about rolling your eyes? Verbalize your frustrations, dear.
Be noted that religious traditions commonly recognize that the creator has instituted human authority as well.
Yes.
In this matter, the people of the state of Michigan, through ratifying the 1963 state constitution, as well as its predecessor constitutions, have established this court and its authority. The people of the state of Michigan, through their elected representatives, have established laws that apply in this court. And the people of this county have elected this judge to serve in this office. And this court has subject matter over this felony prosecution and has personal jurisdiction over this defendant. Any relief sought by this notice is denied.
Perfectly put, very well put. I used to clerk for a judge in Wicomico County Circuit Court who I thought had a very interesting way of putting it that I thought was also a great way of helping people to understand. So not only would we very occasionally on the shore run into sovereign citizens, not frequently, very, very occasionally, or infrequently, we would run into them. We would also come across people that wanted to, that were selected for jury service, but did not want to serve. And some people really do have genuine reasons that they don't want to serve on a jury, one of them being religious beliefs. Some people have a genuine religious belief that they should not sit in judgment of other people. It may be like a sect of Christianity or just like maybe like a localized pervasive belief that they've been taught. Maybe it's more cultural, but some people believe that because they're Christians and the Bible says, judge not, lest ye be judged, it is not their authority or power to sit in judgment of another person in a criminal case. And so we would have quite a few people during jury selection, and I was working for the courts at that time, saying, I don't want to sit in judgment of anyone else. And this judge would say, very stoic, very formal judge. He'd been a judge for a very long time, maybe like 20 years, 30 years, something like that, a very long time. And he would say, okay, well, what is your religious belief? And all the time they would say that they were Christian. I didn't hear anyone say otherwise. And he would say, okay, so that means that you follow the Bible? And they would say, yes. And he was like, well, in the Bible, it also says to render unto Caesar that which is his. Are you aware of that? Yes. And do you know that that means that, if you're following the Bible, it says to follow the government, right? And a part of our government process is that you have to serve, at least present yourself to serve on a jury. And that is a part of rendering unto Caesar what is his, giving your service to your state, your government, your country. And a lot of the time people will be like, well, that's true, and like maybe they come up with some other reason after that, or maybe they yield and eventually end up answering the necessary questions to see if they could sit on the jury. But I always thought that was a very elegant way of saying, like, I recognize your religious beliefs. I respect your religious beliefs. I think he might have been a Christian himself. He never said that, obviously. But, like, I maybe even follow your religious beliefs. But despite your religious beliefs, there is a separation between the government and your religion, right? We have freedom of religion and freedom from religion. So a part of our civic duty is jury service. A part of our civic duty is to submit to the authority of the court. And in spite of whatever religious belief that you may genuinely have, that is going to be superseded by our governmental, our obligations to our government.
As to the fourth notice, defendant claims that this court and the government exist only because she allows them to exist. To the extent that this assertion reiterates the proposition that our constitutional republic is found...
What did I tell you about the eye rolling there, Natalie? I know these are quite stupid, but still.
...on the consent of the governed, such proposition is axiomatic as a general matter. However, this proposition does not require that the government must obtain consent or permission from each individual person before exerting governmental authority over that person. Such an idea is nonsense.
You like that clip, hey, Natalie?
This judge, all this editing is banned. This is not me. But this judge is giving her a civics lesson, right, in the midst of making his ruling. This is, I think, an amazing speech that he's giving her. It's not just like, shut up, you're wrong, moving on to the next subject. He's explaining to her appropriately why the sovereign citizen belief system is untenable in our system of government.
Yeah, there's a few more seconds of it.
And would result not in a constitutional republic, but in anarchy. This defendant's views would render all criminal laws null and void, which is legally and practically absurd. Therefore, any relief sought by this notice is also denied. All right. So, Ms. Christensen, all of the claims and papers that you have filed, I have found to be lacking in legal and factual merit, and I have denied any such relief. And I'm entering a
That's fine. Can you please stop referring to me as a defendant? And I guess the next.
Oh, don't.
I told you it gets good.
Step will be, I guess I got to do the actual filing of the claims if you're going to deny all of those.
Well, I don't know what claims you're talking about. You filed some claims or notices or requests.
No, I did not even file my claims yet. I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitution.
Natalie, what did I tell you about the eye rolls? Come on, dear. They can't see those.
Constitutional rights as a woman.
She's not talking about that thing where they like file civil attachments and liens on people.
Yes. Yes, they are.
Ruin people's lives, because that's just harassment.
Yeah, she is.
Not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant.
You defended Angela. You defended Angela. Guess what? You defended Angela. You defended Angela. That's what you are.
I'm not a defendant.
Well, you are.
Okay, in your opinion and legalese, yes, but I am a woman. So do we need to do trial by jury when we can do my claims and file my court with your court at the same time? That's going to be my next step, to file claims against everybody involved in this case. Because there is no verified claim, and complaints and claims are two different things. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step. And I will file proper claims with the proper people and the insurancing for the bonding. So.
Told you.
Does she think she's like making threats that anyone is going to be afraid of? Because
yes,
no one cares. Go and do your little, legal mumbo jumbo. But the judge, talking about he's speaking legalese. The judge is telling her the truth. He's telling her what it actually is. And she's either going to accept it or not. But the court has the authority of the police state. They have the authority of law enforcement at their disposal. They have the authority of the correctional facilities at their disposal. There's so much authority there that you cannot overcome it by just making up your own belief system.
That's what she believes.
I don't know what you want to do at this point. I really don't want to have to do that.
Ms. Christian, I got to tell you, I don't know what in the heck you're talking about. You're talking nonsense. So here's the thing. I am not going to relinquish my authority in this case. I'm not. All right? The prosecutor's office can dismiss the case. They're choosing not to. So that means we do have to go forward to a jury trial unless you want to plead guilty. All right? But what I'm also going to do is your ramblings here today and at previous hearings, and after I reviewed your written notices, it's clear to me that you have no concept of the legal and factual issues at stake.
I would never know anything about legalese because I never went to school to do that legalese. So I don't know.
Do not interrupt the judge. I have a feeling he's going to lay the hammer down on you in about 10 seconds or so. But shut the hell up.
I understand that.
Legalese is just really a slang term for really technical legal speak. It does not have any real force of law. understanding legal concepts is something that many people can do with the correct study and instruction. However, it takes years of study, instruction, and practice in order to fully understand the legal system, which most people are unable to avail themselves of in time for their trial, because you have to teach yourself the law, and then you have to learn all the legal nuances of your own case, and then you better be there in time for trial. Most people are not going to be able to do that. That's why it's always better to use the assistance of an attorney. The person who represents themselves has a full for client.
Yes,
The
they
judge
do.
is assessing that this woman does not have the ability to avail herself of knowledge of the legal system and her own case because she won't even accept reality. And her filings must have been very rambling and he said full of nonsense. So, in order to protect her, he's likely going to assign her an attorney, even though she doesn't want it.
All right, you're illustrating my next point, and you have no respect for the authority of the court. You continue to interrupt me and such, and file these nonsense claims. So I am hereby withdrawing my consent for you to represent yourself.
Ooh.
I'm referring this matter to the Office of Assigned Counsel for appointment. So any papers you file in this case, I will reject because they have to be filed.
Well, I don't accept that offer, and I do not require
Stop an offer.
you to give me a court-appointed attorney, and I will self-govern because that is my right.
No.
I don't want an attorney. I don't do legalese. I'm sorry. I'm not trying to be rude or disrespectful. I'm trying to be very decent.
No, you're not.
I stand on my paperwork, and I'll do the rest of my paperwork. I will keep doing it, and now I'm going to file my claims, so that's fine. But no, I don't need no legal counsel. I refuse that offer. I do not accept that offer. I'm sorry. With all due
It's not an offer. It's
respect to you, I don't accept that.
Well, Ms. Christensen, it wasn't an offer. So
That's why you like that.
This next for a docket call on February 14th at 10:30 in the morning, and I'll refer it to the Office of Assigned Counsel for you to have an attorney at that hearing. You are no longer allowed to represent yourself in this matter, and you will be in person in my courtroom at that date and time.
I'm sorry, but I cannot be there. I can do it via Zoom, and I don't accept that offer either unless you want to compensate me for my gas and my time. So I can't do that. I can't afford to. Sorry.
Ms. Christensen, it's not an offer. I want to have you here because you've expressed such disregard for the proceedings. I want to have you here so you can hear attorney. Ms. Christensen, stop interrupting me. It's not an offer. You will be here, or I will issue a warrant for your arrest if you refuse to attend in person. All right, we'll see you February 14th, or I'll issue a warrant for your arrest. You have a good day.
Have a nice day.
You know, I don't want to see Miss Christensen get arrested, so I hope that she takes herself to court in a timely fashion. But a lot of these things like Zoom court, virtual court, and even the ability for you to represent yourself, they are graces. They are graces from the court. Your right to represent yourself is not absolute, okay? And every state interprets that right differently, and they can revoke it if they have reasons to believe that you're incompetent to represent yourself, that no amount of pretrial preparation is going to make it so that you can competently represent yourself. Some judges don't care. So some judges will just be like, all right, well, screw yourself, see if I care or not. This judge clearly does care about the fairness of the prosecution to her, even though she's being very rude to him. So he's not doing this in order to be mean to her. It's in order for her to have a level playing field. And as far as her ability to appear virtually, I don't blame him for saying that she has to physically come into court, because a lot of people are getting real fast and loose when it comes to Zoom court and being very disrespectful in a way that they would not otherwise be had they been in court in person. It's not to say that people were not disrespectful when court was in person all the time. It's just that I see an uptick in misbehavior because people are sitting in the comfort of their own home. So I get the judge in that regard. I would love to know what you guys think in the comment section down below. And I will.
Thank you, Natalie. We got one more for you, dear. Let me go ahead and find that one for you. Okay, here we go. I'm going to take you, my dear, to 36th District Court. As Mike would say, 36th District Court. You are in the 36th District Court. Did I mention you're in the 36th District Court?
Mr. Lamont Brown, we are appearing by Zoom, and we waive being physically present in the courtroom. And your name, sir? Unmute yourself, please.
My name is Lamont Brown. Good morning, by the way.
Good morning. Today is the day set for sentencing. The court has had an opportunity to review the pre-sentence report. On behalf of the people, are there any additions, deletions, or corrections? None on behalf of the people, Judge. On behalf of the defense, are there any additions, deletions, or corrections? No, Judge. We reviewed the report last night, and there are no additions or corrections. All right. With respect to sentencing, is there anything on behalf of the people? Nothing on behalf of the people, Judge. With respect to sentencing, is there anything on behalf of the defense? Yes, Judge. Mr. Brown is 32-year-old father of 4, ages 8, 6, 4, and 3. His son, the 8-year-old, lives with him on Brentwood in Inkster. It's a stable residence. He's been there 7 years. Pays $970 a month for rent. And significantly, Judge, he's the owner and operator of 4 Brown's Cleaning Company, which power washes cars, boats, deep cleans homes, and cares for their lawn care needs also. He's prepared to pay his court costs for today and his arrearages forthwith to the court. All right, would your client like to make a statement on his own behalf? Yes, he would.
Okay, so that was a pretty standard what's called mitigation for your client. So they already had a pre-sentencing report. The prosecution in Michigan, they're called the People. They decided to submit on what was in the pre-sentencing report. And what Miss George did was a very standard and thorough mitigation for the client. Talked about the background of the client. It's clear that payment's going to be an option here, so his ability to pay, the fact that he has a business to run, children to take care of, those are the type of things you want to tell the court in order to either lessen or avoid altogether your client going to jail. The more ties to the community that they have, the more responsibilities that they have, and the more it seems like they're not going to commit the same offense again, the better off it is for your client. So this is a very good sentence.
So that's a very good setup, I'm assuming.
In my opinion.
Okay.
Sir?
I was just waiting, but good morning, Your Honor. Pretty much like she said, I really don't get in trouble like that. It was just a driving mishap. So I actually just purchased a truck. Like I work every day. I'm up 6 in the morning every day. Get my kids to school, then I start my business. My hours of operation is very meticulous because I work through all of the night and day, depending on when people need things done. And was asking for leniency on my sentence. Like I said, I'm prepared to pay a fine today. Any type of cost that I can knock out the way. On my pre-sentencing statements, it was saying about probation, and I was just asking for the court or the judge, is there any way that I can work around it, or y'all could work with me in any type of way due to my work schedule? You know, I ain't really dealt with probation since I was like 19. So that's what I really remember, like going down, checking in, and calling every morning to determine when I come in or not. Because I just want to get this over with so I can get back to my regular life and finish and prosper.
All right.
So what the client just did, Mr. Brown, is allocution. So that's what he says himself about the sentence that, he wants to impose. Usually it's a time to express remorse. That's always very helpful. These are driving infractions, but still, they're serious enough to carry jail time, probation, things like that. Looks like the pre-sentence report suggests probation, and he takes issue with that or recommends probation. And so he made a case for why he doesn't believe that he should get probation. I don't really think, honestly, what he said was too bad so far. The only thing is that it was maybe minimizing what he was in court for, and judges don't necessarily like that. But it really wasn't. It really wasn't that bad. Like at this point, I wouldn't be like grinding my teeth.
Don't worry, we have stuff for you to grind your teeth before we're done, as the old commercials would say. But wait, there's more.
Sitting next to him as my client.
The court is ready to impose sentence, and I will do so as follows. The court will accept the recommendation from probation for probation. I'm going to reduce the months to 12 instead of the 15 that they recommended, and that puts us in November of 2022 with a final review date of November the 4th. With the following terms and conditions, you shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis, or as often as they require, in person, in writing, over the phone, or via Zoom. You must notify probation immediately of any change of your address, phone number, or employment status, and you must pay the following fines, costs, and fees. The court is going to impose, as to each counts 1, 2, and 3, the mandatory cost on each count of $210. On count 1, the license plate unlawful use, the court is going to impose.
Judge, count 3 was dismissed.
That is the voice of the defendant's attorney, just so you know.
Excuse me.
No, sir. No, sir.
No. So after the judge has given you the opportunity to state what you needed to say in your allocution, once the judge is rendering their decision on sentence or issuing an order after hearing argument is done. There's no more time for argument after the judge has given you your time to state your side of the case. And it seems like here the judge did give him a bit of a grace. So they asked for 15 months of probation. The judge only gave 12 months of probation. The client wanted none at all. And again, I understand that, but the judge imposed it anyway. The probation serves as an incentive for the person to follow out the sentence as the judge saw fit, and to make sure that they do not commit that same offense or other offenses in that interim period of time. So there is a service to the community as far as probation is concerned. That's why it was imposed. So it's not a good idea to cut off the judge at this point in time.
No, it isn't.
I'm really talking to my attorney.
No, sir. I'm talking. You don't get to talk to your attorney while I'm doing sentencing. No, sir. You're right. So I don't mean count 3. I mean count 4. So it's counts 1, 2, and 4.
Correct. Thank you.
Okay. All right. So, and then on count 1, the court is going to impose a $250 fine. On count 2, the court is going to impose a $200 fine, and on count 4, the court is going to impose a $175 fine. With respect to the probation oversight fees, the court is going to assess those fees on count 1. Probation oversight fees are $35 per month. The total 12 months is $420. Additionally, the court is going to impose the pre-sentence investigation fee onto count 1. The total fines, costs, and fees on count 1 is $980. On count 2, $410, and on count 3,
count 4, Judge.
Count 4. Thank you, counsel. I'm sorry.
You're good.
It's $385. The total fines, costs, and fees is $1,775. You have the duration of probation to pay that amount.
That's a lot.
It is a lot, but guess what? As I like to say, there's still more.
Additionally, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall submit to random urinalysis and pay the outside agency directly. The court notes that you failed to appear for your drug screen that was ordered by probation. Had you appeared, sir, it is my turn.
And a way to get there.
It is my turn.
So y'all didn't let me
It's
talk.
my turn. If you keep, I let you talk. I said, do you want to
I see a lot of people having this problem in Zoom court in particular. So I'm talking about myself in virtual court. I've seen people having a hard time with cutting off the judge. I know it's difficult, especially, and what I mean with that is, civilian witnesses, defendants. I see them having a tough time with this. You cannot cut off the judge. It does not help your case. It's never going to help your case. And when given the opportunity to make your statement, say everything you need to say then, even if you don't agree with the judge's ruling, if you're in a trial court, you have the right to appeal almost any ruling or verdict, an application to modify your sentence. There's so many things you can do post-trial, but as the judge is delivering their sentence, it's not going to change it by interrupting them, and it might make it worse by interrupting them. So it's just not a good idea.
And if you want to make another statement, you will do so when I give you the opportunity to. But you will not interrupt me.
You tell them, Your Honor.
Had he appeared for the drug test and I had a drug test result, then I may not have ordered the drug screen. However, I do not have a drug screen result, and therefore he is going to submit to your analysis. If the screen is negative after 2 times, then the court is going to discontinue the testing. Additionally, I'm not going to order the 20 days of community service as recommended by probation. I am going to order, and I'm also not going to order the no alcohol. I am going to order that he pay all outstanding tickets in full. According to the report, he has a $2,292 balance. Additionally, he's going to attend the driver improvement program, and he shall not drive without a valid license. So I don't know how he's getting around in the middle of the night and doing all of this cleaning cars and stuff and whatnot, but he shall not drive without a valid license. If he receives another driving infraction while he's on probation, that is a violation of his probation. There is an opportunity for early discharge from probation if all of the terms and conditions of probation are met. And then the court is also, of course, going to order that he shall clear up all 14 of these outstanding warrants that he has at 36.
I told you, dear. I told you there was more.
District Court and 19 and one at 19th District Court, and then he has one at 16th District Court and one at 43rd District Court.
That's a lot of outstanding warrants. Are those all for traffic-related matters? Wow, he really should be quiet.
But wait.
Outstanding warrants.
But wait, there's more.
From 20th District Court and 18th District Court and 22nd District Court. He has 14, 15, 16. He has at least 16 outstanding warrants. He has at least 16 outstanding warrants. He shall clear up those outstanding warrants, or that will be a violation of his probation. The court is going to set a review date for February the 4th at 9:30 via Zoom. We are going to mail a copy. Probation will contact Mr. Brown at the phone number that ends. Is there anything further at this time on behalf of the prosecution?
Yes.
On behalf of the prosecution.
I thought you'd like that.
Use your listening ears, sir. She was very clear on behalf of the prosecution, not you, sir.
Thank you. Mr. Brown, you're not going to come in my courtroom and think you're going to change my process and my procedure. You will not do it. Anything on behalf of the defense, Miss George.
Judge, on the February 4th, 2022 court date, does he appear by himself, or am I still in the case on that?
You're not in the case. Your appointment ends at sentencing.
Okay, Judge.
All right, and then Mr. Brown, what is it that you would like to address the court with?
Like when I was talking to my attorney yesterday, and like I was telling her, even with the probation, is there any way I could just pay the fine and be done with it? Because I'm gonna be honest with you, I'm gonna fail the probation.
Okay, well then let's just come on in and go to jail.
It's gonna come.
Oh, this is oh my gosh. First of all, Miss George is remaining the consummate professional. The prosecutor is being very professional. Obviously, if you're the prosecutor, you don't want to even get involved in this. Does it have nothing to do with you? So you don't want to say anything. But the defense attorney is being very professional at this point in time. But you have to think of probation as a trade-off for jail. Probation is a grace, okay? And I tell clients this, that if they don't believe that they can do probation, they don't think they can comply, some people just can't do it. Like, they cannot, consistently go in to see an agent, get tested, stuff like that, and they prefer to just spend time in jail, and then when they get out, have nothing hanging over their head. And for sometimes these, like, minor, and when I say minor, I don't mean it's not serious. I just mean that it's not a murder, so these minor traffic cases, sometimes for these types of cases, judges will say, if you can't do probation, then you can go to jail. And I have actually, rarely, but it's happened, had clients say, you know what, I just prefer to go to jail. And they go to jail for some period of time, and then they get out and they're no longer on probation. Say they pay the money sometime after, they get a deadline to pay the money, and then that's it, right? In this case, he's thinking that he's going to avoid jail and probation, and that's just not going to happen. It doesn't seem like with this judge in particular. And it seems like he has a lot of aggravating circumstances in his case that led to the recommendation that he get 15 months of probation on traffic offenses.
It's going to come, the decision between, because I'm by myself. I got to make money to support whatever I'm doing. And it's going to be coming between me having to go to work and me having to go to probation. So I ain't saying, yes, I should be punished for what I've done, but the probation terms is like, and then you factor in things that have nothing to do with my case. Even with my tickets, most of my tickets have been thrown out. I have paperwork from the Secretary of State that threw a lot of my infractions out. That's not the right number you got, I'm saying. They threw a lot of my infractions out.
Well, you pled guilty to them, sir, so it's a little too late for that. And now you owe thousands of dollars in back tickets.
So I don't have that many. That balance that you said, that's not my original balance for my tickets. And I was just wondering, what do they got to do with this case that proceeds now? Oh. Even with me having to, all right, even if we get on a probation, having to go pay this, having to go pay extra to go.
Hey, dude. Take a look. You're on Zoom court. Take a look at the judge in the window. Read her body language. You're not helping yourself here. Shut the fuck up and take your punishment like a man. I know that's going to be hard for you, but dude.
Kind of hard for a person. That's kind of hard. That's going to be hard for me. By myself. That's going to be very hard for me.
It's a punishment. It's supposed to be hard, You could be in jail. That would suck. I'm not unsympathetic to the difficulties of being on probation. It's very tough. But with him having all those outstanding warrants, some judges would just lock him up. And then the warrants could be served on him while he's in jail. Oh, the judge.
That's going to be very hard for me, man.
She's so mad.
I'm by myself, phone kids. I got custody of my first kids. I'm a
football. So, Ms. George, let me ask this question. Let me ask this question. Stop talking when I start talking. So, when the plea was taken, and maybe I'm not clear, because I didn't take the plea. It was taken on the felony docket. Is Mr. Brown suggesting to me that the judge, at the time they took the plea, did not advise him that for each count, it's a penalty up to 93 days in the Wayne County Jail, up to $500 in fines plus costs, and up to 2 years probation? Was that explained to him when he took the plea? Oh, yes. That he pled to 3 misdemeanors? Correct. And that they are punishable by up to 93 days in the Wayne County Jail and up to $500 in fines plus costs and up to 2 years probation. Was that explained to Mr. Brown when he took the plea? Yes.
This means your pleas are falling on deaf ears. Everything was followed according to the law. You were advised accordingly, and you voluntarily pled guilty being advised accordingly. It's very hard to argue for a sentence far underneath what is recommended when you voluntarily entered into a plea and knowingly entered into a plea.
Judge, and the felony was dismissed in lieu of a misdemeanor plea.
Okay, so then I'm confused by your statement, Mr. Brown. So here's where we are.
Ma'am, I don't know what you...
Sir, you're not going to keep interrupting me. So we can withdraw his plea and he can go back and deal with it as a felony, or we can go ahead and do my sentencing. But what I'm not going to do, I'm not going to explain the law to Mr. Brown. I'm not going to explain why you can't be walking around with 16 outstanding warrants for your arrest. In a minute, I'm going to start adding some jail days. Ooh. That's what I'm going to start doing. Ooh. I'm not going to explain why you can't walk around with 16 open warrants. Yeah. I'm not going to explain what one thing has to do with the other, because that's not what I'm here for. That's not my role. And I'm not going to engage in somebody else's role. So,
that's a tough thing for a lot of people to understand, is that it's not the judge's role to explain the law to you. It is not the judge's role to make sure that you understand what you're doing, right? It's your attorney's job to advise you accordingly. Now, the judge is going to go through a plea colloquy with you, and the plea judge did do this, to make sure that you're doing everything knowingly, intelligently, and voluntarily in order to protect it. But as far as education is concerned and advisement is concerned, that's the job of your attorney, right? And so what she's saying is that it's not her job to argue back and forth with him about the sentence she's already imposed.
Either we can go ahead, or we can go and send it back to the felony docket. And I don't know what the penalty is on the felony docket.
Years.
I don't know how many years he can get in prison on the felony docket for this thing that was reduced to a misdemeanor. But it is clear that these 3 counts that he pled to are an inconvenience to his way of living. Ooh. And all I can say is that probation is an alternative to jail, and jail is an alternative to probation. So I don't know what we're asking me for, but this isn't just a give me a fine and let me go on my way. And not only is he asking me to just give me a fine and let me go on my way, apparently he don't want the fine on all of the counts and the cost on all of the counts, because he doesn't understand what that has to do with anything. So I'm not here to explain myself.
He'll be in such a worse position if the plea is withdrawn, because he's pretending like he doesn't understand what's going on, because then he'll be facing the felony charge, and with the felony charge, you are more than likely looking at jail time.
I'm here to impose sentence. So either we want to go ahead and do the sentence and try to work the probation, or we want to go ahead and withdraw the plea, take it back to the felony docket, and handle it as a felony.
Don't do it.
Because I'm confused. Miss George?
Judge, I'm sure he can work it out with probation to report by Zoom or by mail or something. I'm sure it's workable.
Well, of course it is, because everybody else is working it. I'm sure it is.
Thought you like
something
that.
that he's not going to do. He just said he's going to fail the probation. And when he fails the probation, because he has made up in his mind that he's going to fail the probation, then it's going to be jail. So there's no sense in doing that. Let's let him go back now, since he's already made up in his mind that he's going to fail. And when you come out the gate with a defeated attitude, then there's nothing that you're going to be defeated.
Judge, you gave him an option to close him out early if he gets everything all cleaned up.
I sure did.
And
but he was
you can't do any better than that. You can't do any better than that.
Well, I didn't think I could, but apparently I can. Apparently I can do better.
The attorney is trying to impress upon her client that this is the best you're gonna get. And the judge is telling him, you're talking yourself into jail, sir.
And correct me if I'm wrong. Are there 3 counts?
3 counts, Judge.
Mm-hmm. Madam Prosecutor, are there 3 counts?
Yes, Judge, that is correct.
You're going to like this, Natalie, because it actually gets worse. Again, you're rolling your eyes at me, and I know you could go, how does it get worse? But it does, and let's go back to the tape so you can see that.
3 counts.
Okay, and I sentenced him on 3 counts. Did I not?
Yes.
Okay. Mr. Brown, since you think you're gonna fail, would you prefer to just go to jail, sir, or what would you want me to do?
Ma'am, this is what I said. I said the stipulations, it's going to be hard. I might fail. That's what I said.
No, you didn't say I might fail.
He said he was going to fail, which means I'm not going to try because I don't want to do it.
I've been on probation since I was 19 years old. So I'm misremembering for me going on probation at 19.
And you don't think we do anything different from since you were 19?
I've been in this type of stuff since I was 19. You get what I'm saying?
No, I don't, and I don't want you to talk to me like that. I don't get...
He's very rude. And he's, you know, he thought at the beginning that he was being polite, but I actually found him to be rude from the very beginning. You know, like, oh, yeah, well, good morning anyway type of thing. He has an attitude problem, and he's really going to need to fix that because it comes across to the judge. And it's making her mad, and this is the person that holds their freedom, your freedom, in their hands.
What you're saying, and I don't.
I was just asking that stars in the stipulation of probation. Okay, I got $2,300 to pay with, $1,700 to pay with y'all. Bam. But every time I'm going to drop, I gotta still pay month like.
Well, if you had Bam went to drop that first time, you wouldn't have to drop.
Ma'am, I wasn't aware of it.
Ma'am?
You don't have to be aware. I wasn't aware that I had to explain myself to you. They did tell you to go to the drug test.
Okay. All right. I just see. If I tell you something, you just gonna be. I wasn't aware of the drug screening. I ain't been.
They didn't even tell you to go. Let me bring the probation officer in.
Catching you in a lie, because before you said, you didn't say that you weren't aware of it. You said that you just couldn't get there, that you had transportation issues, but you were aware of it. Don't lie now.
Can you get Miss Williams, please?
Get Miss Williams.
Can you have Miss Williams come in, because Mr. Brown says she never told him to go drug test, and I need to know why she put that in her report.
Ma'am, I didn't hear her say it. All right, ma'am, can you just send this?
Oh, you didn't hear her say it. That's why you got all these warrants out right now. You can't follow directions.
Yeah, we need to just move on with the process.
Okay. Thank you.
Your Honor, can I get sentenced and move on?
I didn't think you were. I didn't think you were talking to Your Honor, because the way you talking to me sounds like you talking to your person, your homeboy or something.
That's right.
So now all of a sudden that I'm calling now that I'm trying to make sure, and I'm calling Miss Williams because you said you weren't aware of the drug test. Now you want me to move on and you want to get sentenced. You told me you weren't aware of the drug screen.
She's calling your bluff, and I don't think you've had your bluff called before like this by an authority figure that you can't talk your way out of. She's calling your bluff.
Ma'am, I just,
Your Honor. Remember, I was Your Honor.
Your Honor, I don't want to just go. It seemed like it's not working for the best of me right now, so I just.
It probably was seeming like that, and that's why you probably should have let Miss George do the representation.
I cannot say this, you know, it's clear that Miss George gave him correct advice in the very beginning, the day before when he spoke to her. And he's saying, as I told Miss George, clearly Miss George does not want to present your arguments because she knows that your arguments are not going to work. Please listen to your attorney. Your arguments are not going to work, number one, because factually they just don't make any sense. And they're counter to the facts that are known on the ground. And number two, it's not in your best interest to plead your way out of probation when the alternative is jail. It's not no probation, no jail, just pay the money and it goes away. That's not the position you are in when you were facing felonies.
But you just insisted on saying what you wanted to say. So I'm insisted on listening. And now that you have said you didn't know about the drug test, I want to find out why Miss Williams would put that in her report.
Oh.
Because what we don't do in Judge Bryant's courtroom is come in and lie. And so certainly why would she put that in a report? Certainly she needs to be written up for putting that in a report that she ordered you to go to the drug test. Certainly she needs to have her supervisor notified that she is putting false information in a report, because no one will submit a false report to me and I not address it. Of course they would not.
That's why you ain't got no hairline now, because she just gathered all your edges.
So let me say this to you, Mr. Brown. We're here in courtroom 339 and we're changing lives and making a difference. We're helping people. You have come in here this morning with a whole bunch of excuses and now accusing Miss Williams of not telling you about the drug test. Listen, if you want to work, see, here you go again. Here you go. Go ahead. Okay, I'm going to sit back and let me say this. I'm not going to speak until you're done. Oh!
I thought you'd like
That's the only
this.
thing I got to say, Your Honor. I wasn't aware. I don't know if she told me or not. I just wasn't aware. Is that it? If you want me to go down there today, right now, and submit the drug screen, I'm going to go do that as soon as we get off the Zoom interview. The Zoom court day. I don't have no undefeated persona, what you say. I don't have none of that. I don't have
tell you what you're not going to do. You're not going to go tit for tat with me with everything I say. What I say is not up for discussion, Mr. Brown. I don't say things so you can give me a response. You tell me what you want me to know about you, and that's it. Don't give me a rebuttal to what I say.
He didn't even understand. He didn't even understand what she just told him.
Very
he didn't
likely
even
not.
understand that.
Okay. As I said, we're coming in here with excuses. I have to work all day. I don't have time to do this. I don't have time to do that. You have 3 counts on a case that started out as a felony. We're going to figure out how to get it done. We're going to figure out if we can pay the money or not, if we need a different alternative. We're going to get it done. But what we're not going to do is come in with my experience from 10, 15 years ago on a probation that Judge Bryant wasn't presiding over and interject these things into my courtroom. So we're going to just try to get it done like everybody else does, right? And then we're going to not think that we have the equal opportunity to everything that the judge says. I'm going to respond and rebut. That's not going to work out good for you. No. That's not going to work out good for you. So we're going to work together to get this probation done, to get these fines and coffin fees paid. I don't know if they went over the advice of rights form on the felony docket. That wasn't me, but they should have. And if they had, it would have said, if you can't pay the fines, costs, or fees, you notify the court, and then they'll try to do something different. That's what the advice of rights form should have said. But I didn't take the plea. I pride myself on. I'm not your average judge. I don't know what you're used to, but if you come in here and you want to be argumentative and combative, every time I'm going to win the argument. Every time.
Clearly.
Look at Miss Williams. They called her and she showed up. Miss Williams, he backtracked now. He backtracked. He backtracked, Miss Williams. Thank you for coming in, though. Put your name on the record for the record. Dawn Williams on behalf of the probation department. Good morning, Earn. Good morning, Miss Williams. I was just gonna try to verify, but he changed his mind because you put in a report that that on October the 11th. Did they tell you which case this is regarding? Yes, it's Mr. Lamont Brown. Yeah, you put in the report on page 6 that on October 11th, 2021, the defendant was given verbal and written instructions to screen for alcohol and drugs at ATS by October the 13th. And then he had forgot because he thought that he wasn't aware of the drug screen. And I wanted to know why you would put that in the report if it wasn't true. But I think he remembered. So I appreciate you coming in, though, Ms. Williams, because I wanted you. I didn't want somebody to, I wanted you to have an opportunity to speak on it. But he remembered that you did tell him and that you did give him a paper. That you may have given them a paper and instructed him to go to the drug screen.
Thank you, Your Honor.
You're welcome, and thank you. All right. Have a great day.
He picked the wrong one today.
Yes, he did.
So I gave the review date of February the 4th at 9:30 on Zoom, and he's going to be assigned a probation officer in a short time frame. And if he does not receive that, he can call the courtroom. If they don't reach out to him, he can call the courtroom, and Ms. Muldrow will be more than happy to let him know who the probation officer is. Is there anything further for this record?
No, Judge, thank you.
Nothing for the people, Judge. Thank you. All right. Then we're all set. Mr. Brown, you have a great day and stay safe.
I would love to.
All right, thank you very much, Natalie. I'm going to let you go and get back to your folks. I appreciate you being with us for both of those cases today. Hope to do it again in the future. As for us, of course, this will be the end of our part 2. Come back for Art Bell in the overnight. Like, share, and subscribe. Get us to those goals of 5,000 views and 1,000 subscribers. So Boxing Extras and YouTube will pay attention. And until then, always make sure your fights are great in Dominion. Like, share, and subscribe, and come on back for more from day one.